All right, good afternoon, everybody, and welcome to the MSHA Hazard Complaint and Whistleblower Protections webinar for the 2016 Conn Maciel MSHA webinar series. Thank you for joining today. My name is Nick Scala, and I'll be the first voice you hear today. The second one will be that of my co-chair of the MSHA practice group, Justin Winter. Today we're going to be talking about working through hazard complaint investigations and also some of the outlines of MSHA's whistleblower protections. But before then, for those of you who have not joined us before, my name is Nick Scala. I am the co-chair of the MSHA practice group here at Conn Maciel Carey. I represent mine operators and independent contractors all around the country in MSHA investigations and inspections, including those related to hazard complaints. We work with clients through all types of MSHA litigation, as well as preparing clients for investigations. Prior to getting into this area of law, I worked in the mining industry and am a certified mine safety professional. The other person who will be joining us today is Justin Winter, and I'll let Justin introduce himself.
Good afternoon. As Nick said, my name is Justin Winter. I'm the other chair of Conn Maciel's MSHA practice group. And as Nick mentioned, our practice group represents mining companies and contractors throughout the country, dealing with MSHA investigations, MSHA inspections, handling MSHA citations, and of course the issue that we will be discussing today, whistleblower protections. I did not grow up in the mining industry, but I've been doing MSHA law since out of law school, and Nick and I have been working together since that time, and I'm glad to be speaking with you today.
All right, thank you. So to kind of give an overview of where we're going to go today, is we're going to start just from the basic elements of what is a hazard complaint, what kind of investigations are these, and how are they initiated. Then we will discuss the different types of investigations and how MSHA may be reacting differently depending how that complaint is made and by whom. Lastly, we will discuss an overview of whistleblower protections and also what to expect during a whistleblower discrimination case under the Mine Act, which is Section 105C of the Act itself. So with that, we are going to be moving through these separate parts and kind of giving you an outline of where maybe the hazard complaint could cross the line and turn into an area where hazard or discrimination claims could arise. So first, we know that MSHA does all kinds of inspections, and we all know that the inspections are not limited to the minimum 2 for surface mine and 4 for underground regular inspections each year. And in fact, MSHA has an entire enforcement activity code section in their handbook series for inspectors. And in that, we can see that regular health, safety, and health inspections are listed as EO1, and that's what you may have heard an inspector or someone else refer to these inspections as. But aside from that, they have many other types, whether that is a spot inspection, a special emphasis program, which is an E17 at the bottom of that page, which could be an impact inspection or a blitz, however they may term it at that time. MSHA also has separate categories for fatal accident, non-fatal accident, or non-injury accident investigations. And each one of those is a different type that, in addition to the minimum 2 that you are going to get a year if you're a surface operation, that you could receive. Now, right at the top of that page, we see that there's an EO3 and an EO4 listed. And these are the hazard complaint investigations, and MSHA has 2 different types for that. Typically, what we see with an EO3 complaint investigation is that it stems from a written hazard complaint filed under Section 103G of the Mine Act. And what this means and what the small print next to that chart says is that special inspections that respond to a written notice filed pursuant to 103G of the Act alleging a violation or an imminent danger at a mine. Now, typically when we have an imminent danger or a violation alleged under a written complaint in this section, MSHA is going to respond with a very formal and very quick investigation at the mine site. Now, this can be done, through written complaints to the agency, and that is typically done by minors representatives, or applicants for employment as minors. And that is one of the reasons that this type of inspection or this type of investigation is responded to so quickly, because in the Act they wanted to assert some provisions that if a minor or a minor's rep or someone of that status filed a complaint, it would be addressed quickly. Typically, also, we see a very quick response if there is an allegation of an imminent danger. Now, these are typically what we're going to be considering a traditional hazard complaint, in that we see these more often than the second kind, which would be listed as an EO4 or verbal hazard complaint. And this is an inspection that results from a verbal or otherwise written complaint where a violation or hazardous condition is alleged and is not a request under 103G. So this typically means that it does not have to come from a minor, a minor's rep, or an applicant minor. And therefore, these are handled less formally and may even be handled during the next regular inspection, depending on the allegations that are levied against the company. We see these less so because typically if there is a complaint that has any validity, it's going to be coming from a minor or a former minor or someone of that status. But the verbal complaints do occur, and they typically occur when an inspector is on site and provided some information at that time.
And to switch gears from the more informal type of complaint that Nick was just referring to, Section 103G also goes into detail about the more formal written notification hazard complaints. And again, as Nick mentioned, this is the more common type of hazard complaints. And there are some guidelines that MSHA actually lays out that must be followed when a minor or minor's rep is making a written notification hazard complaint. The written hazard complaints that allege an imminent danger will result in immediate MSHA attention. MSHA will commence an inspection at that point. The mine operator will not get notice of this inspection. It will commence as a normal inspection would, in the sense that MSHA will essentially show up. What will differ is how that inspection transpires. The inspector will go through each allegation made during the complaint, and before that inspection starts, the type of allegations and the specific allegations themselves will be discussed between the inspector and the mine operator. And MSHA must follow certain steps when they initiate and complete this investigation. The written hazard complaint notice must be generated initially by a minor or minor's representative, as I said before, and this information must be shared with the mine operator, but the identity of the complainant is kept anonymous. Some more information from the Mine Act itself concerning this type of written complaint. As you see here, any such notice shall be reduced to writing, signed by the representative of the miners or by the miner, and a copy shall be provided to the operator or his agent no later than at the time of inspection, as I said before, right when the inspection starts. The name of the person giving such notice and the names of the individual miners referred to therein shall not appear in such copy or notification. MSHA does go to great lengths to make sure that the identity of the complainant is not disclosed in anything that they generate to the mine operator. Again, some more information about the written hazard complaint. Upon receipt of such notification, a special inspection shall be made as soon as possible to determine if such violation or danger exists in accordance with the provisions of this title. So this inspection will start right away, as I said, no notice, and although they will be on site to investigate each specific allegation made, it could be one allegation, it could be several. Of course, it's also important to know that MSHA can cite for anything that they see on site, even if it's unrelated to the allegations. EO3 written hazard complaints are made by a minor or the minor's representative. Those are the two parties that can commence a written hazard complaint that will result in an immediate inspection. the complaint alleges a serious or imminent hazard or a violation of a regulation will result in an immediate inspection. There is a difference between the type of allegations made. The allegations made may not rise to the level of resulting in an immediate inspection if MSHA does not believe that an imminent danger exists, or if the danger that's alleged by the complainant doesn't rise to that level. So again, the allegations will oftentimes vary in severity. The immediate inspections commenced by MSHA will result from those that will rise to an imminent danger. And once on site, MSHA pretty much has the authority to commence a wall-to-wall, very thorough inspection. Again, it's important to note that not everything that's listed in the allegation complaint may be discovered by the inspector. However, other things may be cited. The inspector can cite for anything that he wants, even if it's unrelated to the allegations. And according to the Mine Act, the reporting mines or representative names will be kept anonymous. Again, it could be an anonymous hotline that's actually called by the complainant, and it's not the mine operator's right to know who makes the complaint. And this goes to my next point, which is important, and it actually is connected to the Section 105C topics that we will be discussing later. It's a slippery slope to try and seek out who made the complaint. Of course, mine operators may have an idea of who made the complaint. It's natural to want to find out who did it, but it can possibly lead to some retaliatory action. This is one of the protected activities, actually making the allegations in a written complaint. So it's best to let the process play out and not go full board in terms of trying to find out who made the complaint. MSHA makes it clear that they're protecting that information, and they don't want the mine operator at this point to know who did it, and they're going to go to great lengths to keep that information confidential. So best not to do that and conduct your own internal investigation at that time to find out who may have made the complaint.
So in addition to the formal 103G setting where we are getting a written complaint from a miner or a miner's rep, there is also the EO4 inspections or the EO4 complaint investigations. Now, in these investigations, as we talked about before, MSHA's responses, depending on the allegations levied, could be different and maybe even less immediate in how they are approached and how they are responded to. The EO4 inspections could be in writing, or they may be verbally communicated to a member of MSHA, either the inspector or someone else higher up in the food chain there. But it is not required to be in writing at that time and signed by the actual complainant. Now, typically we do see that there is some sort of connection, or that MSHA has some discussion with this individual. However, again, it is unlikely at the initiation or the onset that the company is going to find out that name. And that is having to do with something that MSHA likes to invoke called the Informants Privilege, meaning that individuals informing against a mine operator, their identities can be concealed. And that is also the reason why under 103G, we typically don't find out who is making our statements. And that is to protect against discrimination as well as other adverse action that an employer may take against them. Additionally, though, for a hazard complaint, it doesn't have to come just from an employee or a potential employee. It could come under this circumstance from anyone who believes they may be seeing a violation or a violative act. And that could be a contractor, a customer truck driver who comes on site and believes they see something they shouldn't, or even as far as to say someone of the general public who drives by or believes that something is occurring that shouldn't be. Now, again, that is why these are treated maybe with a little less urgency than the 103G complaints under EO3 investigations, because those, as they come from an individual working or potentially working for the mine, MSHA addresses them quickly. So again, these might not happen immediately. It may be during a future investigation or a regular inspection, but MSHA could also always investigate these when they are received or at their earliest opportunity thereafter. The EO4 complaints will go in a similar fashion to the EO3s in that there will be allegations. These allegations will be provided by MSHA and should be provided at MSHA at the onset of the investigation when they get on site. Typically why imminent danger orders are moved at so quickly is just because in the definition itself, it is believed that a danger is imminent. And although recent case law would suggest that that definition may not be how the imminent danger orders are actually enforced, it is still what MSHA is going to look at. Is there an imminent likelihood of death or serious injury if said action or said condition is not corrected? And that is why they move so quickly on the 103Gs. Also, MSHA has the authority to investigate these at any time. And again, they can continue to investigate them as long as positive findings are found. And what we mean by that is during this, MSHA is going to be looking at whether or not you have a positive or negative finding for each allegation. And what we always like to tell clients is that the best way to stop the chain of hazard complaints is to have negative findings. And that's a very obvious statement. However, just like anyone who continuously goes to investigate someone who cried wolf, a series of negative findings over a single hazard complaint or over multiple hazard complaints will undoubtedly affect how MSHA is going to be looking at future complaints, the veracity of them, or if they are starting to get a number of complaints regarding similar topics, yet all are negative findings. This could affect, when the inspections occur, how the inspections are handled, and so on and so forth. So when we are managing a complaint investigation, Justin mentioned it briefly, but one thing we should not do is our first course of action should not be to try and find out who made the complaint and take action against them. We will discuss that later on as why that is a bad idea for mine operators in terms of the risks that lie in front of that in terms of discrimination action. This could be a deliberate blow or a deliberate violation to the Mine Act's Whistleblowers Protection, something that MSHA takes very seriously and will aggressively prosecute and aggressively pursue during investigation. So we want to be careful to, yes, we want to correct any conditions, and yes, we want to make sure that our workforce is aware of what is going on, but we want to also be careful not to alienate anyone who we believe may have made that or that we know. Oftentimes our workforce is not 150, 200 people at a single location. Sometimes it is, but we, at times most likely can put a name or an idea of who is making this complaint. And even though we may have that idea in our head, we need to be very careful to take action or even interact with them in any way that could be construed as negative or discriminatory. When we actually have the investigation going on, first we should always get at the beginning, at the onset, a copy of the inspector's findings and the allegations. If we are going to have this investigation take place, as we said, there will be negative and positive findings identified for each allegation. Additionally, there should be some supporting documentation from the inspector that will report the support for those findings. Whether or not they were positive or negative, they will likely have written down some of their reasoning or evidence as to why they believe it was true or untrue. Now, you may not be entitled at that time to those findings, but nonetheless, you should take steps to either request them at that time, request them through counsel, or take the steps yourself to file a Freedom of Information Act request on the event to get as much information as you can, especially if you have any positive findings. Operators should also carefully prepare for investigations by coordinating with their upper management. all of our personnel should have some understanding of what their rights are when MSHA comes on site. However, obviously management and senior management are going to be the ones that need to handle or be involved in these investigations with hazard complaints. Also, our recommendation would be, depending on the type of complaint and when and how they are being investigated, if they are alleging imminent dangers or if they are alleging wrongdoing by mine management, you would likely want to get legal counsel involved and at least apprise them of what is going on, the status, and the allegations that are being put against the company. Beginning the process of privileging your notes is also an important step. Now, this is done when you are working with counsel and you can inform us of an ongoing investigation. And if you call Justin or I would, as clients, I believe the first thing that we would probably say is please take notes on our behalf and label those as privileged attorney-client product and attorney-client correspondence so that we can take notes about what is occurring and who is involved without those being immediately discoverable by MSHA. We would have very good arguments that these are attorney work product and therefore reserved for our use alone. We also want to make sure that our employees know their rights, and this should be covered in training previously, but at the onset of any investigation, whether special investigations for agent liability or investigations as to complaints, we recommend that you provide some form of documentation or review of their minors' rights that is very explicitly unbiased, in that you are not trying to direct them to go one way or the other, but that you are just offering them the information that they are available or able to talk with MSHA, that they don't have to talk with MSHA at any time if they do not want to, that no adverse action will be taken against them if they cooperate with MSHA. So lastly, just to summarize, who is able to make these complaints? As we talked, in terms of the EO3s and the 103Gs, this is going to be coming from a minor, a minor's representative, or from an applicant for a minor. It is specifically listed for those. Typically, there's going to be someone involved in an employee-employer relationship or a possible one who feels that there is an imminent danger or some violation existing on site. The second one, classification of people, are those who believe they've witnessed or are aware of unsafe activities or violations on the mine site.
So now we're going to actually discuss the provisions in the Mine Act under Section 105C that give protections to miners who engage in some protected activity. Really what we're discussing here are safety complaints, and we're going to go into that in more detail in a couple of slides down the road. But essentially, the Mine Act includes MSHA's authority for handling and prosecuting retaliatory action by mine operators against miners, miner reps, or applicant miners who believe they were punished for a protected activity. Now, when we're discussing protected activity, the following activity actually, are the most common actions on the part of the individuals I referenced before that will give them these protections. One, identifying safety hazards to your superiors at a mine site, requesting MSHA inspections from MSHA. As we discussed before, mine sites can be subject to any number of inspections. Making hazard complaints and contacting MSHA to request an inspection is protected activity. Excuse me. And then refusing to engage in an unsafe act or task.
Take over from there. All right, and some other options for protected activity, some other areas where we might see a protected activity described for a miner would be requesting or the right of a miner's representative to accompany MSHA on inspection. If that is denied, the right to see training, receive minor training with no loss of pay, right to receive task training or request that training or act as a miner's representative. and anything, or the broad scope is the right to exercise any right under the Mine Act. So protected activity can be a broad topic, and some of the most typical ones that we would see is, is an individual identifying hazards, requesting an inspection through complaint processes, or refusing to work or take on work assignments they believe to be unsafe or in violation of the law.
So just some more information about whistleblower protections under the Mine Act. Whistleblower protections under the Obama administration were greatly expanded. 2008 campaign promised to increase whistleblower protections for workers, which they did. Across industries, the prosecution of whistleblower cases has increased substantially, including through the Department of Labor. The Section 105C complaints and actions actually taken up by MSHA, because not every 105C complaint actually results in a case from start to finish, that increased substantially under Joe Maine's tenure. This was one of his kind of pet projects. It was always built into the Mine Act, but there were efforts made by MSHA to make sure that all miners and miner representatives and applicants were aware of these rights, that while they were in the Mine Act, were not always well publicized. And MSHA initiated several practices towards enhancing their awareness, walk and talks to inform miners of their rights. Inspectors were actually trained to discuss Section 105C on inspections, which was something that, while they may have done prior to Joe Maine's tenure, they did not do with the level of frequency that they did under Joe Maine. And therefore, not surprisingly, Section 105C complaints and prosecutions rose sharply during the past several years. It's something that we've seen a great deal of over the past 8 years. And Joe Maine, has a lot to do with that. He takes a lot of credit for it, and it really has to do with awareness. These protections were built in there, but in the past, it was possible that some miners, their reps and applicants, engaged in the protected actions that we discussed before, and they were not aware of any recourse. When they were made aware, these cases just exploded, and it may have decreased just a bit recently, but it's still at, the past few years at its highest level that we've ever seen it.
And these are, there are certain elements as to building a claim under whistleblower protections, and those protections can be under 105C of the Mine Act, 11C of the OSH Act, or it can even be a whistleblower claim, whether in the securities and exchange, in the financial industry, or any other type of industry. We've really seen an increase, as Justin said, across all federal prosecution of these. So what do we need, or what does the government, if they're taking forward, need to establish, or how do they establish that a retaliatory act, or discrimination occurred? Well, as Justin said earlier, we're looking for if there's protected activity engaged in by the complainant or by the individual that pursues or makes a complaint of discrimination. The employee must establish that they engage in activity protected by a specific statute under which it was filed. Well, we went over some of the list of individual exercises or activities that can be classified as protected under the Mine Act. And as we saw, they can vary from requests for accommodation on personal protective equipment, such as fall equipment or glasses or gloves or something along those lines, all the way to refusal to work if it is believed that the condition they are being asked to work in is unsafe. Next, there must be an adverse action by the employer against the employee, and it must demonstrate the complainant suffered some form of adverse action by the employer. Now, we'll talk more in detail about adverse action in the next few slides, but essentially there must be some sort of action taken against them, whether that is, as clear-cut as termination or maybe as convoluted as suspension. Adverse action, its definition, has really grown to be expansive under the last few years of case law in an environment that has been favorable for complainants. So we have seen a lot of that, and a lot of that is that, as Justin said, Joe Main has been a proponent of this for specifically the mining industry and making this known, and also for really digging into the provisions that have always been in the Mine Act and enforcing them with renewed vigor. Next, there must, though, for retaliation claim be a causal connection. And so what do we mean by that? The employer would not have carried out the adverse action but for the protected activity done by the employee. So there has to be some sort of connection between what was done as protected and what the employee or employee minor suffered as adverse conduct. So also when we're looking at this, we are exploring whether or not the standard is met. So an employee must show that the action, might have dissuaded a reasonable worker from making or supporting a charge of discrimination. So even though the adverse action could be termination, it could also just be doing something that persuades or intimidates an individual, or in their opinion intimidates them from pursuing a discrimination claim. And it must be either material adverse and to a reasonable employee or applicant. And the reasonable person standard, or the reasonably prudent person standard, is a fairly common one that we see across the legal industry as a whole. But within the mining industry itself, the judges look at what would a reasonably prudent minor believe to be the case under these circumstances, or in this case, even a reasonably prudent minor applicant. So there are some qualifications on what must be proven or established to cause an adverse action. Additionally, some other types of adverse action would be, failure to hire, failure to promote, if they believe it is because there was adverse action, protected activities taken into consideration. It can even be as small as a poor evaluation if they believe that that has adversely affected their employment or their ability to move up or move on. There is also things such as denial of overtime, layoff, or failure to recall, depending upon the circumstances. And again, these very nuanced claims are why we need to discuss and be prepared with our documentation and having established HR procedures and following those procedures, which we'll bring up a bit later. So specifically, what are we looking at? Some more language that is included in the Act itself is no person shall discharge or in any manner discriminate against or otherwise interfere with the exercise of statutory rights of any minor because the minor has filed or made a complaint under or related to this Act, including an alleged danger or safety and health violation. So we put this up here because obviously this is showing the direct link or the coordination between making a hazard complaint and the potential for a discrimination claim based on the action the individuals or the operators take following that. And this really goes to that causal connection that we were seeing, or that we talked about, that there must be a but-for connection, meaning the adverse action would not have taken place but for the employee acting in the protected activity. So we are really looking at how are the two related, and this is taken directly from the Mine Act and demonstrates that we are looking at hazard complaints or the filing of hazard complaints as a specific element identified as one that can trigger discrimination claims. And that's why we said earlier, if a hazard complaint is made, we must tread carefully in moving forward trying to identify or take some action against the individual who filed that complaint. So as we said earlier, there is a spike in these prosecution, and not just the investigations, but the prosecution. And it's an important distinction because, there is both investigation and prosecution of the claims. And prosecution means that MSHA believes that discrimination did happen or most likely did happen, and they are going to take the case up for the individual. The investigation itself is more the fact-finding mission that the MSHA investigators will seek out and begin. and the prosecution will then be handed off to their attorneys in the Department of Labor. We've also seen a trigger lately, or a switch lately, where we're not just looking at where there was adverse action, but also it's looking at the part of the statute where it says, or otherwise interfere with the exercise of a statutory right of a minor. And this is an important distinction that MSHA is starting to pursue these cases, because the interference means that there does not have to be a specific adverse action, so to speak, that it can simply be that there was interference with their ability to exercise these rights. So again, it's a effort or a trend by MSHA to expand their reach on these claims. Lastly, for me on this, and then Justin's going to discuss more about the investigation and prosecution, these are intensely pursued. As was mentioned, these are, one of the initiatives or emphasis programs that we've seen pushed by the administration and by the agency head. So they are going to be looked at and scrutinized, and they won't just be a cursory gloss over. The investigations are very similar to 110 investigations as agent liability, if you're familiar with those. And the difference being that minor statements, although it's hard to believe that they could be more influential or more impactful, may even be more so for complaints or discrimination complaints, because MSHA is really going to be looking at, did the minor who alleged this discriminatory act, has there been other similar behavior, or has there been dissimilar behavior or actions toward other minors? So we want to look at this in terms of, if there is a claim or there is a bereavement within the minor community at our plants, we want to make sure that we look into them, and that especially any safety and health complaint provided to us as the employer, as the operator, by a minor are investigated. And likely it would be a good decision to write down that we investigated said claim on said date, and here was our findings, whether that is, after investigating whether or not this piece of equipment was operating without a guard, it was determined it was not, or the guard was replaced. We want to make sure that we recognize what efforts we are making to follow up on those complaints.
And just some more information about the actual investigation of a 105C complaint and the timeline you can expect. The original complaint must be filed with MSHA within 60 days of the alleged act of discrimination. Again, these are hard deadlines that the Act actually stipulates. Further, the MSHA investigations of 105C complaints must commence within 15 days after receipt of the complaint. So once MSHA receives the complaint by the complainant, if the investigation is not started within 15 days of receipt, essentially the case will not be brought up by MSHA. Some more timelines here. Within 90 days of receiving the complaint, the Secretary must inform the complainant of the determination regarding the claims of discrimination. So MSHA also puts a timeline here for communication between the complainant and the Secretary. This timeline, the 90 days, little to do with for the mine operator this time, but this is to just mandate some, a 3-month communication time frame here for the Secretary and the actual complainant. And if the Secretary does not find discrimination occurred, the complainant will have 30 days to file the complaint with the Commission pro se. Essentially, that means that although MSHA will not take up the case for the complainant, he or she still has the right to take up the complaint themselves before the Federal Mine Safety and Health Review Commission. And some additional information for you concerning the prosecution by the Secretary. As you can tell from the timeline information I just gave you, MSHA is not required to pursue every 105C complaint, as some claims may be baseless. There's a generous time for MSHA to conduct their investigation, as Nick stated before. They will communicate with the mine operator. They will conduct interviews. It's a pretty intensive fact-finding. And through that fact-finding, it's safe to assume that some claims will have a foundation and some will not. And it's up to MSHA's discretion whether or not to pursue each and every 105C claim that is filed. And if MSHA does pass up on taking up the complaint on on the part of the minor or for the minor, it doesn't mean that that individual can take up the claim themselves or actually go outside the Federal Mine Safety and Health Review Commission altogether. This doesn't preclude civil claims. But MSHA in the past has taken up the cause for more 105C complaints than they have at any other time in its existence. And temporary reinstatement is another important topic that we want to discuss. MSHA will most likely attempt to obtain temporary reinstatement, or TR, on behalf of the discriminated party if a job was lost, which would put the minor in their previous position with their previous pay. And it's a pretty low bar to prove temporary reinstatement. What will happen is the secretary will bring a TR, will request a temporary reinstatement hearing in front of an administrative law judge. And all that has to be proven is that the minor could prevail, and that is a very low bar. Most temporary reinstatement hearings do result in reinstatement of the minor at their previous position with their previous pay. And temporary reinstatement can be sought, and most oftentimes is sought, before the completion of the investigation. Because the bar is so low, MSHA may not even know if this is a baseless claim or whether there is a foundation for it. But because the bar is so low, they can still prevail at the temporary reinstatement hearing, even if eventually they find that there was no base or foundation for the claim. So that's important to keep in mind. And TR is not available to pro se complainants. And to kind of just take the trajectory of the 105C case through to the hearing before the Federal Mine Safety and Health Review Commission Administrative Law Judge, what they will look at the actual 105C hearing is whether the minor was engaged in an activity protected under Section 105C. Nick went into detail concerning those protected activities earlier. Whether the minor suffered an adverse employment action as a result of those protected activities, and whether the adverse employment action complained of was brought about due to the protected activity on the part of the complainant. MSHA has the burden of proving the connection between the protected activity and the adverse action. It's up to the mine operator to show that the action that was taken was not related to the protected activity. So the mine operator will want to show that there was some other work-related reason for that adverse action, that it had nothing to do with the protected activity. And if they could show that, it would be difficult for MSHA to prove the burden of showing the connection between the protected activity and the adverse action.
So with this, it's also important to know what can we do to protect ourselves or to prepare for these types of circumstances, and how can we better respond to such allegations or to such investigations. So if there is a complaint and we know which worker is alleging the complaint of discrimination and they're still employed by us, we must ensure that no further adverse action or retaliation or anything that could be considered such is taken against them. As Justin said, if the individual is no longer employed there, they are eligible for temporary reinstatement during the remainder of that case while it's taken forward, which these are slow-moving cases if they're prosecuted. So that can be years of putting someone back in work or paying them to stay away from work. So that is, something that we want to avoid, that if it comes about and we know who it's talking about, we want to make sure that that is something we take no further action against that person. We also want to conduct our own investigation. We want to look internally to see what happened and what occurred. As you had to go forward in this, you have to conduct an investigation to find out whether the events were timely. As we said, there are strict timelines for when the investigations must be initiated, once the claims must be initiated, and how MSHA moves forward. And there is that 60 days to file the complaint by the discriminated party. That is from the date of the adverse action. So if we have our own investigation to figure out maybe by the allegations what day that was and they were a month late filing, that would obviously undercut the claims. We also want to record the investigations and findings and interview employees with knowledge of the claim. And again, this is another reason why we advise, if you are working with counsel, to get in contact with them so that we can begin to work on these processes with you, or through your own internal procedures to privilege them for the purposes of future litigation. It is also possible that you may want to begin preparing a position statement for response. And again, this is something that we recommend you work with counsel on to make sure that you are not admitting or stepping outside of what is permissible or what is proper in these terms. But a position statement, a written statement that can be provided to the investigating agency, is a useful tool, hopefully to undercut or to cut short some of the interview process and investigation processes. So how do we get to this point? How do we get to we know what people should be doing and when? And that is train, train, train. We want to keep training our individuals. Direct supervisors and managers must be trained on retaliation and how to manage protected employees. Now, this is a must. This is an area that we are seeing increased activity. Whether or not that activity will be lessened under the new incoming administration is yet to be seen. However, for the time we are at now, and in the future, in the next few months, we are likely going to see these increased levels of complaints and prosecutions. And even if the incoming administration wants to knock back on those, which they may or may not, the investigation tools and the inspections still can occur. Maybe not as frequently, but they are still out there. So specifically, management should receive instruction on how to respond to complaints, types of actions that are likely considered adverse, which we've discussed, perception of retaliation in proximity of time. That's that causal connection we were discussing before. Did it occur because of a certain but for an action, and were those reasonably linked in time, meaning did the person file a complaint against a safety and health violation that they believed existed 2 years ago, and now they're alleging that that's why they were terminated, or that's why they were shifted to a new work area? That has to be something that we look at too, is what is the perception or the relation of time. We also want to effectively communicate with legitimate but adverse employment action. So what were those adverse actions and how are they connected to protected activity? And we want to document our legitimate responses to employee conduct. So what does that mean? It means if someone has violated our own safety policies and procedures and we have provided them according to our HR policies, we have given them the opportunity to correct it, we have retrained them, we have given them verbal warnings, written warnings, time off, and then they are terminated. We have followed our procedures for legitimate reasons. They were acting unsafe, or they failed to wear PPE. We want to make sure that we document those as well. So lastly, we want to make sure that prior to and at the time of the action, we maintain clear and written documentation of all disciplinary action. We detail our decision-making process and maintain tightly following our policy and procedures, so we don't want to treat individuals differently. And we document all our training instruction provided on the policies and procedures. Now, I guess fortunately, MSHA has been increasing how they review and what they determine to be in compliance in terms of our record keeping. And all that, though that has created some headaches, we should have, at this point in time, very detailed and accurate records of what training was provided and at what point, especially when we're looking at task training and the emphasis on that lately. If there is an allegation of discrimination, we want to conduct an investigation. And even if there isn't, even if this is just an internal claim, we want to conduct an investigation of any complaint of discrimination or retaliation. And we want to document that. Keep the notes of the employee interviews, reasons for why we came to what determination, just like that helps us when we're trying to contest those citations or allegations in an MSHA hazard complaint. This is also a tool for us, or a shield for us to put down when MSHA or any federal regulatory body is looking at a discrimination claim. So we want to be able to provide certification of follow-up actions, and we want to be able to apprise the complainant of findings and resolutions. So transparency is a big part of this with the actual individual party. We don't want them to feel slighted if we're dealing with an internal complaint that may then be reported onward. And with that, we are finished up for the day. We are happy to take any questions. Of course, we will continue to broadcast articles and blogs on the MSHA Defense Report that are related to mine safety and health. Additionally, we will be doing a 2017 webinar series that will be released shortly to all of you by email and on the webinar or on the blog and the firm website. We will be doing the monthly webinar series for the entirety of 2017. So there'll be 12 of them, and we hope that each and every one of you has the opportunity and continues to join us. With that, we are open to take any questions you might have at this time, or if there's a question you'd like to follow up later, please don't hesitate to get in contact with either myself or Justin. All right, well, it looks like we were just so clear and concise today that there aren't any questions at this time. So, again, thank you for your time and attention. We hope that you all have a fantastic holiday season with your families. And if you do have anything that comes up, please don't hesitate to contact either myself or Justin with any questions regarding hazard complaints and discrimination filings or any other type of MSHA situation. So thank you very much, and everyone have a great day.